Hello and welcome back to the Idaho Legal Aid Services web series on eviction in Idaho for non-payment of rent. This is part 3 of the series in which we're going to talk about the eviction case itself. So after the 3 days have passed from the notice of non-payment of rent, and if you haven't been able to pay your rent, or if you can't pay your rent, your landlord at that point will have the opportunity to file a case with the court to evict you. This is done under Idaho Code 6-310, and that section allows for an expedited process. Expedited process means that it's quicker than other court cases. For cases involving non-payment of rent, the court will hold an eviction hearing within 12 days of your landlord filing the case. So a lot faster than other cases where you have 21 days to file an answer. If you are unsure if your landlord has filed a case, you can either check with iCourt, that is icourt.idaho.gov, or you can call the civil clerk at your local county courthouse and have them look up your name to see if anything's been filed. So Idaho Code 6-310 has some requirements that have to happen before the hearing. Like I said, the hearing will be held within 12 days from the day your landlord filed the case. That's not 12 days from when you received the 3-day notice. This is 12 days from them filling out the complaint, filing it with the clerk, and starting the case. You must be served with a copy of the complaint that your landlord completed, as well as a summons and a notice of when the hearing is going to be. And you have to receive all those papers no later than 5 days before the hearing. These papers are different than the 3-day notice, which your landlord could serve themselves. With these, you have to be formally served. So you'll either be handed them by a police officer, maybe someone who is a professional process server, so someone whose job it is to serve people court paperwork like this, or it could be someone, as long as they're over 18, who is not a party to the case. But just so you're aware, your landlord cannot be the one to hand you these forms. Also, and this doesn't come up often, but eviction cases have to be filed in the county where the rental property is located. You do have the option to file an answer with the court in response to your landlord's complaint. So the paperwork they filled out to evict you, you can get a copy of a self-help answer through the court assistance office, either by going to their website at courtselfhelp.idaho.gov or by going to the office in person at your local courthouse. There will be a filing fee that you'd have to pay, but there is also a fee waiver request. I'm sure that if you're unable to pay rent, it would be difficult to pay a filing fee as well. So it makes sense to file both of those. And in your answer, this is going to be your chance to raise any defenses you might have in writing with the court. And that can be useful. And just as kind of a summation of the defenses that we've talked about, these can include improper 3-day notice, your landlord listing the wrong amount of rent on the notice they gave you, not giving you the proper 3 days to pay your rent, refusing to accept your rent, filing in the wrong county, or even potentially not serving you with the eviction complaint forms at least 5 days before the hearing. If you do not have access to a printer to get the forms, you can go potentially to a library, to a friend, to your local legal aid office. You could also go to the courthouse, like we talked about, to their court assistance office.